So we'll go more into the kind of, I guess, intermediate ground of what can be done in this space. But on the one hand, you have the kind of, patent, put it through the the kind of medical route. And on the other hand, you have the kind of decriminalization, legalization route. And this is also actually, I think this is the last time I'll mention Compass, but I think there was also a case of, again, talking about monopolization, where you have this measure 109 in Oregon that successfully passed to legalize psilocybin therapy. And there were reports that the CEO, George Goldsmith, had been contacting researchers at a local university to mobilize opposition against legalization, which it fits with the kind of, as we said, we're not trying to kind of read people's intentions, but it fits with a perspective of an intent to monopolize or to profit in a way that's limiting access, that where you see legalization or decriminalization as something that's going to kind of impact your bottom line instead of, so it comes back to this kind of profit over access route. But do you think decriminalization, do you think we'll see a kind of patchwork where like certain places might decriminalize, certain places might legalize? Are there lots of different kind of routes that we could take here?
Well, yes. I mean, I don't have a crystal ball to understand exactly how that will unfold, but I think we will see. I mean, I'm very hopeful we'll see. I mean, I think, decriminalization should have already happened. It should happen as soon as possible. I really like the legalization model in Oregon. We were talking about this alternative universe of where maybe drugs wouldn't have to go through FDA approval to be, used as medicines, and the Oregon model kind of presents one possible alternative universe for that. Although, of course, psilocybin's a medicine that's not entirely new or really new at all. So that's one kind of caveat. But yeah, I mean, I definitely see going to Compass, like, of course, if you have a kind of single fixation on profit maximization, you're going to want to limit these other avenues as much as possible. I mean, I think that's certainly what they say on their website is that they see the medicalization route as being the correct route, and certainly what I've heard. And I think there was just another opinion piece from a psychiatrist who's affiliated with them maybe within the last week about how retreat centers really shouldn't be allowed to operate, or it's not appropriate for them to operate. And you can, I don't know his intentions behind it, but it is part of a bigger picture of wanting this to be through a very specific route to access, because the revenues from that route to access flow back to a single company. And so that's definitely can be seen as problematic, and that's one thing, however, that the patent system is really designed for. I mean, when a patent is granted, it means that period of 20 years, the person that benefits, or the company that benefits from that, is the patent owner, and that patent owner is generally a single entity who is able to kind of extract all of the value from that invention. So that's the sort of baked into the design of the patent system.
Right. Yeah. And the value of this, I mean, if they were successful, they could be looking at billions of dollars, I'm assuming, in terms of, as you were saying, with the pharmaceutical industry, there's a lot to be made. And it's not controversial to say that a lot of people are looking at psychedelics as potentially revolutionizing mental health care treatment. So if you do have a monopoly on it, yeah, there's a lot of money to be made.
Mm-hmm. Yeah, I mean, that's absolutely true. I mean, I think that's what excites many people about this space. Obviously there's people in this space that are excited about the fact that it is potentially transformative of mental health care, or for cultural reasons, or for other reasons. And there's a lot of people who I think are excited about it because of the potential for profit from those things.
Right. And so when it comes to other approaches, I think it's interesting to compare this kind of for-profit thing that's happening with psilocybin and Compass to what's happened with MAPS, the Multidisciplinary Association for Psychedelic Studies, and they've been a huge player moving forward MDMA-assisted psychedelic psychotherapy, but they're a non-profit, right? I think USONA as well is another example of a non-profit. How does kind of non-profit drug development sit alongside this for-profit model?
Yeah, well, that's a good question. I mean, I think we know where it sits now to some extent. I mean, we've seen it be very successful with both of them. I mean, MAPS is, of course, the furthest along with their MDMA in phase 3 trials. But the question, I think, will be how successful can that continue when there are, other ways for people to make money now in the psychedelic space. And I'm not really super familiar with their kind of fundraising efforts and who they've been raising money from, but there's certainly a question whether some people that gave MAPS money 5 years ago did it because they were really excited about seeing psychedelics being more mainstream and being adopted as potentially medicines. And those same people may see that now there's a way that they can continue to support that effort, but also make more money back from it. So, I think there's still a difference with MAPS, because MAPS, I think, kind of has two goals. And one of them, of course, is to be able to turn MDMA into medicine. And the other one is really to look at drug policy more broadly and to find ways to sort of push forward to having this, licensed, I guess, model where people have access to psychedelics, not just through their physician, but for other purposes too, which many of the for-profit companies probably won't be doing right away. Although, I guess if we see legalization efforts take place, there may even be investment opportunities there too for adult use or kind of recreational psychedelics. So yeah, I mean, it's definitely a counterexample to the necessity for patents to support clinical research and FDA approval of a drug. But I think it's also potentially just sat at a very unique sort of period of time where there was no other kind of way for somebody to get involved in this industry. I would like to think that that's either something that will continue, or maybe there'll be a balanced approach. And I think we are seeing, some of the investment funds taking something of a balanced approach, similar to like Journey, like Vine Ventures has set aside, I think a full half of their like general partner profit toward a trust that gives back to the community. So there's people who are thinking about ways to kind of balance the profit maximization and the sort of public benefit aspects of things. And I've not kind of done a survey, but I think there's many more companies who are public benefit corporations than there are in a lot of other startup spaces. So hopefully people are taking these things to mind. Maybe answer your question. I don't know that there's a perfect answer to it. I think we'll have to see if MAPS can continue. I know MAPS, I think I heard Rick say once that he felt like MAPS will have done their job if like people didn't remember MAPS in the future, because they've like these things have all been they've been sort of destigmatized and now they're available for people to access. But I mean, I would like to think that like people would still be, if not MAPS still in existence, but like following that as like another alternative model to bring drugs to market. And I guess time will tell them.
Yeah, you mentioned early on in the conversation that there was an aspect where nonprofits like MAPS can get exclusivity to certain aspects of the process. I think you mentioned data. How does that work?
Mm-hmm. Yeah, so in the US, the first company to bring a particular drug to market gets 5 years of data exclusivity, which means that all the data that they used that supports their drug approval, nobody else can use that for 5 years. So like when MAPS, from the start of filing their investigational new drug application, their IND, which included all their like, preclinical sort of toxicology data, and then all the data around the, formulation of MDMA through their like phase 1, phase 2, phase 3 trials, all of that can't be used by another company, without MAPS's approval for 5 years. So it means that if another company wants to get MDMA approved for either also PTSD like a generic or for another indication, they would have to start from scratch basically and do everything from the kind of stability studies with their GMP MDMA through like the initial toxicology studies in animals. Everything. They couldn't rely on any of that data. Outside of the US, there's also a period of what's called market exclusivity, where somebody's not allowed to sell a drug either. Would be the same, in addition to the data exclusivity. So like in Europe, there's actually up to 11 years of data and market exclusivity, which would give MAPS, potentially 11 years of exclusive ability to sell MDMA. But in the US, it would be 5. And I think maybe 6 months or a year later if there's like pediatric exclusivity added onto it. But basically, it just means that like there's no easy way for a generic to kind of piggyback off that information and launch a generic equivalent.
Right. And I've seen you write about speak about this idea of an IP commons as a kind of intermediate ground of, in the debate of whether to patent or not to patent. Can you explain kind of what that is and how that would work in this space?
Sure. So I guess looking at the kind of two extremes on a spectrum of like ownership, like on one far extreme, you have everything is in the public domain. So everything's accessible, everything is just open for anybody else to use. And then the other extreme, there is like complete enclosure by individual companies where like every company would have a patent on whether it's a compound or a way a compound is used. And there would be all these competing kind of rights that companies would have to exclude others. So a commons would be sort of a way of looking at IP that sits somewhere in between it, where companies can sort of work together to contribute IP to a, either a kind of like another organization that would be able to manage like the IP of a group of companies, either for like their own benefit or for the benefit potentially of like third parties. So you can imagine, for instance, with like a psychedelic assisted therapy clinic, say you want to open up and say there are a number of competing patents in the marketplace that people have on like somebody has one on psilocybin assisted therapy and someone has one on DMT assisted therapy and someone has one on psilocybin assisted therapy for anorexia. Like the clinic is going to have a lot of sort of transaction costs to kind of investigate where all these rights are coming from and try to license different ones. And it makes it difficult, I think, for in this example, for like a clinic to be able to sort of start. So the commons could work together to like kind of pool those rights and find a way to make it more efficient to like, for instance, license those to, to that clinic. But the commons can be used in a lot of different ways. And so I think like when I think about commons, there's kind of like a legalistic way, which is like how it's structured, which is like looking at the like administration of it and the kind of like legal documents that kind of control it. You could also look at it in terms of what people are contributing. So people can contribute either like IP, like whether it's patents or could be potentially sort of any other kind of IP they have, whether it's research data or sort of patient data. And you can also think of the IP, which I think is probably the most valuable way to think of it, as a kind of someone who's new to it, which is sort of what does it offer? What can it benefit to people who are sort of partaking in the commons? So, one of the ways which kind of reflects back on some of what we talked about earlier is just protection. So people in the commons can come together to do things like identify problematic patents that somebody else may have filed and find ways to try to assure that those patents don't get granted. They can find ways to put provisions into their own patent kind of licenses so that like a troll is not able to acquire their patent and then start suing people in the psychedelic space. They can also sort of work together to try to have something similar to like a kind of, I don't know, like a non-disarmament trust or something, like where, like a, trying to think of what the name is for it in like the military setting, but like a non-aggression pact, I think, where, they kind of agree not to either sue each other for specific things or to like not take certain abusive practices, because there's a concern when people have patents that they're going to be diverting their kind of resources and energy to policing the boundaries of their patents rather than continuing innovation or otherwise kind of benefiting the ecosystem. I mean, so, there's ways to try to like remove or sort of change those incentives a little bit. So protection is like really kind of the foundational one, I think, for a commons, but there's a lot of ways that members of a commons can use their IP to cooperate too. So rather than just to compete over their rights, but to find ways to cooperate over them. So, the example with cross-licensing rights to be able to offer to like a therapist or a therapy center, I think is kind of one good one, but also, you can, for instance, if you pool your patents, you can securitize them and potentially use them as collateral to offer like loans to people who want to start a new business or want to start a clinic. So there's ways that like patents, if they're assembled together by members of the commons, can create sort of new rights or new opportunities for members of the commons or members of the, or like other entities that members of the commons want to support. And sort of a third one, I think, is, or third benefit of a commons would be to take these ethical principles and actually turn them into legally binding requirements as part of an IP license. So that can be done individually by companies, but it can also be done in an organized way where if enough companies together kind of create a critical mass where they want to put these rights into their IP licenses or into the kind of way they contract around their IP, then they're able to like make that a kind of cultural norm that has the ability to kind of transmit those principles to others who may be like kind of newer to the space or getting into the space. I mean, I think the psychedelics space is still pretty young, and that, even though there's a lot of ethical concerns now, a lot of companies are really still approaching the the field in a way that's like they're trying to be intentional about like sort of doing good, but that may not be true as like it kind of gets bigger, and as there's more money to be made and as there's more patents that get granted. And so there's, I think, going to be a developing concern about companies like continuing to have those sort of good intentions. And like people may be concerned now about Compass, but they are maybe doing some things that rub people the wrong way, but like, are they really a predatory kind of actor? And what would it mean for there really to be predatory sort of actors in the space? So there's ways that a commons could be used to like make it more difficult for those sorts of like kind of worst case scenarios to come to pass.